The broadcast is now starting. All attendees are in listen-only mode.
Happy Thursday, everyone. I just have a few announcements before we get started. Today's presentation is hosted by hrsimple in partnership with Fisher Phillips. If you have any questions, please enter them in the chat box and David will get to them throughout the webinar. If you need to view a recording of this webinar or would like to view other webinars, please go to hrsimple.com/events. The slides and recording will be sent to your inbox within 24 hours. hrsimple provides federal and state-specific manuals. All of our books have been updated with new COVID-19 chapters, which include telecommuting policies and agreements, how to handle pandemics in the workplace, and the Families First Coronavirus Response Act poster. Today, you can use code COVIDWebinar30 for 30% off any purchase as a thank you for attending our webinar today. So now we're going to take some time and learn a little bit about our speaker. David Jones is the managing partner of the firm's Memphis office. He practices exclusively in the area of immigration and related employment and compliance matters. He represents clients in complex matters relating to both immigration benefits and enforcement and in proceedings before the Department of Homeland Security, the Department of Labor, the Department of Justice, and the Department of State, as well as in matters related to citizenship status discrimination and export control compliance under the Export Administration Regulations and International Traffic in Arms Regulations. David has extensive experience in assisting companies with hires or transfers of employees from outside of the U.S. in industries such as agriculture, banking and finance, chemicals, construction, energy, entertainment, healthcare, and education. So I'm now going to hand things over to David and we can get started.
Thank you, Anna. Hello, everyone. As Anna mentioned, I am going to be taking questions throughout the presentation. I do, however, want to break those down into sections. And so as we come to the end of this section, I will remind everyone that they can ask questions and we'll try to cover the questions in each section. If there's a question specific to your company or a specific situation, we would likely handle those offline, and I'm happy to respond to those offline as well. So Anna, can you confirm if the screen is showing properly, please?
The screen looks great, David.
Okay, thank you. All right, so we're going to be talking about a lot of different topics today in immigration, some of the current trends we're seeing, issues with COVID-19 and travel, and just how to get through immigration today with terminations, furloughs, and new hires. It's a really complicated situation today, and a lot of companies are finding a lot of challenges in dealing with that. So starting off, we're going to talk about executive orders or executive proclamations on immigration and travel bans that have come out over the last several months or more. So there are specific restrictions that were put in, not specifically related to COVID-19, but related to the U.S. labor market and ensuring that the labor market remains okay for U.S. workers because of the situation with the coronavirus outbreak. And the first of those came out on April 22nd, and it was for immigrants, so people who were coming to the U.S. permanently to live and work. They could be employer-sponsored or family-sponsored. As a practical matter, this was pretty limited because it only applied to people who were already outside of the U.S. And who did not have immediate U.S. citizen family members sponsoring them, and it was only effective for 60 days. So that was followed up on June 22nd with an extension, and in that extension, they set the new date at December 31st is when that one is set to expire. And they added H1B, H2B, J1, and L1 visas. And we'll talk about what each of those visas are a little bit later on in the program. But those are the primary work visas that are available for anyone coming to the U.S. to work. So in many respects, it prohibited individuals who were outside of the U.S. or who needed to get visas in those categories to come into the U.S. Before December 31st, 2020. There are exceptions for different individuals, such as people who have a job that's in the national interest. We've had situations where, for example, an automotive plant needed to be operational, and there were issues with that. They had to bring in someone from outside the U.S. That was considered a national interest because of the jobs and the market. And there are other categories that are exempted as well. So not all J1s are covered by this. In effect, the L1 visa, which is the visa for people who are transferred from abroad, was the one most heavily affected by this. And there are challenges being made. We don't know if this is going to stay this way through December 31st, 2020. It's kind of touch and go on a daily basis. There are also just kind of general travel restrictions related to COVID-19. First off, the consulates have been largely inoperable since March, which meant as a practical matter, individuals who needed to get visas couldn't really do that anyway. They were having to wait to be able to get appointments, and so travel for people who didn't already have visas has been suspended. But then we also have suspensions related to COVID-19 specifically, and there's a list of countries on your screen that if you've been in those countries for the last 14 days, you may not be able to enter the U.S. Without certain exceptions. And we also have an agreement with Canada to close the border. One of the interesting things about that is the border crossing itself, the land borders where you drive across or even walk across, are where this has really been in effect. It's been hard for people to get through those borders without certain exceptions and waivers and so forth. However, we have reports that people have been able to travel from Canadian airports directly to the U.S. without any issue. I think that may be a function of resources that are available for the Customs and Border Patrol that they may have pulled away from the land borders, and that may be why they're making those more difficult to use. So that's just kind of the background for any travel restrictions that we have going on, are things that are out of the normal immigration rules that are in effect right now. And, we have to just kind of take COVID-19 on a daily basis, day-by-day basis, and we'll see what happens with any more executive orders or proclamations through the end of the year. So with that, I'm going to go ahead and, excuse me, and move into what the actual visa options are right now for individuals who are wanting to employ someone, or wanting to be employed in the U.S., or for companies who are wanting to employ them. So we have on the screen several of the primary visa categories that do exist. You saw before, there's the H1 temporary worker. F1 students can work under some circumstances. The J1 exchange visitor covers a lot of categories. H3 trainees, O1 extraordinary ability, O1, another H1B version, something called the E3, TN, which is a NAFTA, E visas, and then immigrant visa petitions. And we're going to go through each of these in order. So the H1B is the most common visa category available for workers, and it's for people who have bachelor's degree level education and they are going into an occupation that requires a bachelor's level education. Normally, or it's so complex that it will require one in this case. And there's an annual limit on those, and there's a lottery to get those. So those of you who are familiar with the H1B may be aware that the lottery is held in March now. It used to be held April 1st. There's a new process that was instituted earlier this year. But they hold this lottery in March, and then they decide who is going to get these visas, and then those visas can be applied for and take effect on October 1st. For individuals outside the U.S., this means with those travel restrictions that those individuals may not actually be able to start their jobs on October 1st because they can't get into the U.S. And then for people who are trying to get H-1Bs now who were never approved for one in the past, there are no visa numbers available unless you happen to work for something called a CAP-exempt employer. So the regulations and our laws relating to H-1Bs exempt employers who the government feels like need to have access to as many workers as they can get. And that's such things as institutions of higher education, nonprofit research institutions, government research organizations, and so forth. These H-1Bs can be filed for at any point during the year. There's no limit on how many there can be. You actually can file a concurrent H-1B for someone who has one of these CAP-exempt ones with a CAP subject employer. And so basically, if I apply today for a CAP-exempt H-1B, I get that, and a week later, I can have a second H-1B simultaneously with a CAP subject employer. But if I ever leave the CAP-exempt employer, I cannot continue to have the other H-1B. Of course, even if I'm filing something for one of these individuals, they're not going to be able to go out right now and get a visa stamp. But if they're currently working in the U.S. already, then we can generally transfer that over. The next category is the F1 student. So F1 students, as part of their just general education, are allowed to work on campus. But after they graduate, there's this idea that you don't really have a full education until you've been able to take your knowledge you've obtained through your education and apply it practically in a work setting. So there is something called optional practical training that will let them work for a year after they graduate. And if they're in a STEM degree field and working for employers who use E-Verify, then they're able to get a 24-month extension, so a total of potentially 36 months. It's also possible to get a second OPT if you get a second or higher degree. And then there are some situations where you can get something called curricular practical training, where while you're still in your F1 studies, perhaps you need to have an internship or something along those lines. And so you're able to work as part of your degree process. And so a lot of individuals will get that and be able to work for employers. This area, this particular type of work authorization has been under fire. There's been talk of redoing those regulations a number of times over the last 2 to 3 years. We haven't seen anything just yet, but we are, we're just aware that there could be changes. And so if you have anyone who is looking to apply for STEM OPT, we are recommending that they go ahead and do that as soon as possible, or even regular OPT as soon as possible, to ensure that they're able to apply before anything could change with that category. The next is the J1 cultural exchange visitors. There's a whole lot of categories covered by this, anything from intern, trainee, a research scholar, summer work travel, and so forth. This is typically in a work context, really used for intern trainees or people who are research scholars. And then they also have a summer work travel program. So a lot of people will come around in their summer and work for U.S. entities. This is one of the categories that has been hit by the new travel restrictions. Most J1 categories are not able to get visas right now. And there are some exemptions, so research scholars are not covered by this, but most J1 categories are. And so we did have a question about the eligibility for J1 programs for winter work that came in on the chat line. As it stands now, it does not appear that a J1 would be possible before December 31st. However, if that individual already has a visa or happens to be in the U.S., it may be possible. And we don't know if, if anything's going to be extended or not, but assuming it isn't, then January 1st, they would be able to come in. So there may be some possibility there. We do know that a lot of J1 cultural exchange programs are taking the position that they can't do anything right now, even a change of status for people who are already here, or even processing for people who may come later. That's based on their interactions with the State Department. We'll have to just see how that plays out. Another category is the H3 trainee. This is fairly uncommon category. The J1, as you saw earlier, has a trainee option. It has an internship option, but the H3 trainee is a non-State Department version. It's a regular immigration service version of a visa for training, and the idea is this is something that you have someone who is in a country who cannot get a certain type of training there, so they're coming to the U.S. solely for the purpose of getting that training here, and then taking it back to their home country and being able to work there. They can't do any productive work unless it's integrated onto the training. So this really isn't an ideal sort of situation to employ someone in the U.S., but there may be situations where a company wants to have this person work abroad and they need them to come into the U.S. to learn before doing so right now. So the H3 is available for that, and it's not affected by the program. The next one I was going to cover is O1, but I did want to mention real quick, there's also temporary visas called the H2A and the H2B that are for seasonal work. The H2A is agricultural work, and the H2B is for, a lot of times it's used for construction or for resorts that are open in the summer, or ones that are open in the winter for seasonal work. The H2B has been restricted through the end of the year. The H2A, however, has not. It is still possible to bring in agricultural workers right now. But the H2B, which is is basically used to bring in different types of labor into the U.S., is on hold. The O1 category is for individuals who have extraordinary ability in their field, and extraordinary is probably a strong word for what we really see on this, but the idea is if you have someone who's at the top of their field, sciences, arts, education, business, athletics, what have you, that this person should be able to get a visa for that. You don't necessarily have to have an employer if it's an occupation that is typically self-sponsored or self-employed. So for example, if you're a musician, you wouldn't have to have an employer. If you're some sort of role like in marketing, where you would normally have an employer, then you would need a sponsor. These are outside of any caps. They're outside of any travel restrictions right now. But the simple matter is that we want to encourage individuals who have, are highly capable in their field to still come into the U.S. There's a lot of variation to what we see as people qualifying for these. There are certain occupations that have hard times. There are certain occupations that do better. But anything that gets a lot of awards, press, or publications, or patents, or any kind of thing that can show that the person has been recognized a lot may be worth pursuing. Occupations that tend not to work very well tend to be in computer science. It's rare to find someone who is in the IT world who can get these unless they're in a high level position, just because of the nature of the work. doesn't lend itself to the types of accolades typically that they'd want to see. But it's something that if someone is accomplished, it's always worth looking at because it can work, and we use it frequently. Next is the L1 multinational transfers. So as I mentioned earlier, this is the category that's probably hit most by the new visa restrictions that came out for the rest of the year. An L1 is basically for someone who is working for a company abroad and needs to be transferred to the U.S. by that same company or related entity in the U.S. There's two basic flavors of this. There's the L1A, which can be for managers or executives, and there's the L1B, which is going to be for specialized knowledge employees. Specialized knowledge is typically something that had to be gained from the work abroad. It's not something that would be readily obtainable in the U.S. The L1A is limited to a 7-year maximum, and the L1B is limited to a 5-year maximum. And you have to have been employed in either one of those types of roles abroad for at least 1 full year before you can be transferred to the U.S. There's a type of L1 called a blanket L1, and this is for companies that transfer lots of employees all the time. You know, big multinational companies just have employees coming and going to the U.S. from the U.S. They can get something called a blanket approval, which basically pre-establishes that the company itself qualifies for the L1 based on all of the legal relationships. And this facilitates the application of the employees because they can just take this document and some forms and go directly to the consulate abroad where they are to get their visa. So they're able to come in relatively easy under normal circumstances. By that same token, however, these individuals, when they're newly coming to the U.S., are much less likely to already have a visa, and therefore new L1 blankets are not possible right now for any employees who need to come over. So that is why that has been hit the hardest. But outside of that particular issue, this is a really useful category for any companies that have multinational operations. There are also some country-specific employment visa options. So, you know, it seems kind of funny to look at, you know, recruiting from specific countries, perhaps. But from a visa perspective, there are countries that are easier to get employees from. The first is there's an H1B treaty carve-out called the H1B one for Chile and Singapore. This is the same as an H1B, but there's a number carve-out such that these visas remain available typically, excuse me, throughout the year. They don't tend to run out, and they're limited to 1 year at a time. But if you have an employee from Chile or Singapore, there would be no cap restriction to getting that individual an H1B1. Of course, they may have issues getting the actual visa at this point because of those restrictions. Then there is something similar to that. I'm going to talk a little about e-visas in general real quick, but e-visas typically are for treaty investors and treaty traders. And then you have other visa categories typically for workers. But through a treaty that we have with Australia specifically, we created a completely new category called the E3. It's effectively the same as an H1B. It requires something called a labor condition application, which is what H1Bs require to show that we're paying the foreign worker an appropriate wage. But there's nothing else that has to be filed ahead of time with USCIS, the U.S. Citizenship and Immigration Services. You simply get the wage document, their credentials, a letter from the employer, and they take this to the consulate abroad, and they're able to get this E3 visa. There's no limit. So in effect, it's possible to employ Australians as you wish, as long as they're in an H1B type occupation, one that would normally require a bachelor's degree in a specific field. So if you're looking at Australian workers, then you always have this option and they're not covered by the presidential proclamation at this point. What we used to recall, we used to call NAFTA, now it's the USMCA, the US-Mexico-Canada Agreement. It's the TN category. The TN category is basically work visas for Canadians and Mexicans based on a schedule of occupation. So there's not a specific sort of threshold that you have to look at for any given occupation to see if it qualifies for a TN. You have to look at the actual list and see what occupations are available. And it's actually quite limited. We had hoped that it would be updated to something more modern with the change in the treaty, but it hasn't been. So for example, the only computer-related occupation on the TN schedule is computer systems analyst. So it can be quite difficult to fit a lot of modern occupations into that, and there are occupations that weren't even considered to exist necessarily when this list was first created. So it can make it quite difficult to fit certain individuals in categories. And then depending on the actual job on the list, they each have their own specific requirements. It typically will be a bachelor's degree or an associate's degree for the TN, but it depends on the specific occupation. Some will require licenses, and there's just, like I said, there's a schedule of all these occupations and what each specifically requires. These can be applied differently. They can be applied in the U.S. They can be applied by Canadians directly at the border. They can be applied for by Mexicans at the U.S. consulate, or again inside the U.S. Through USCIS. There is a category called management consultant, which has historically been the catch-all category. And it used to be that you could kind of fit any kind of position into management consultant. And some people still try to do that. But the rules for the management consultant specifically are that the person needs to be coming to the U.S. to consult on a high-level basis. They're not intended to be employed. They're not intended to be doing productive work. It really is supposed to be a consulting level position. And so that's how those are scrutinized. But depending on the specifics, it still may be possible to work certain individuals into that and be able to bring those individuals into the U.S. Next is the E1 treaty traders and E2 treaty investors. This is not typically something we would see used for employment of individuals. You think more of people coming over to start a business. But the reality is that if we have a treaty with the country, an E2 or an E1 is possible. So for example, let's say we have a British company that is doing operations in the US. That British company can hire British citizens to work in the US to fill those positions under the E2 treaty investor or E1 treaty trader, depending on the role and everything along those lines. Sometimes individuals will create their own companies and provide consulting services. So we've had situations where a company wanted to hire someone and couldn't hire them directly. So they hire, this person would have a company that they would then, contract the work to. And so sometimes you can have a creative solution to get around employment by using, contracting an individual to have their company. And not all countries have these treaties, so we have to look up the specific ones. But for example, most European countries have them. It just depends on the situation. It's not a traditional employment option if you're not an international owned or a foreign owned company, but it is a possibility. Had a question come up about whether new applications at USCIS are affected at this time. The answer is no. Nothing in the presidential proclamations prevents someone from filing anything with USCIS. The issue is whether or not a visa is going to be required. If the person is in the U.S. and can change status, if the person's an F1 student and changing to H1B, for example, that person can be approved for that change of status. and a person can have an H1B approved to be sent to a consulate, but that person, unless there's something changes with the presidential proclamation, is not going to be able to get a visa. And in fact, even for renewal situations, the U.S. State Department is taking the position that they're not allowed to issue those specific visas, period. So even if you were in the U.S. on the date of the proclamation, even if you already had an H1B visa or an L1 visa, if you have to go get another one, the State Department's not going to do it before December 31st. And so as a practical matter, if you can do everything inside the U.S., you're okay. If you have to go outside the U.S. to get a visa, you're going to have problems. So the last option that we would use to employ someone is typically done while the person is already employed. So if you have someone on H1B or some other visa category, that employers would typically pursue permanent residence for that individual through an immigrant visa process. It is, however, possible to skip over the work visa altogether. If someone's outside the U.S., you can sponsor that individual to eventually come into the U.S. to work. Of course, that is subject to the presidential proclamation. The other categories, for example, so someone who is on an F1 status and has 3 years of OPT available because of STEM, it's possible to get that person to the labor certification or some other green card process and go straight to the adjustment of status, which is the last part of the green card process, at which point they get work authorization. And so this can be a way to sometimes skip over a work visa altogether, aside from the OPT. The risk in that situation is, if you're an F1 and you seek permanent residence, you can't really travel outside the U.S. because you're an intending immigrant and you would no longer qualify for readmission as an F1. But it is possible. And obviously, if you have workers who are potentially to be sponsored by a U.S. family or permanent resident family members, that can be a way to shortcut the work visa as well. So I don't see any other questions on options for employment. So I'm going to go ahead and jump into the next section, which is how COVID-19 interacts with H1B. And so a little bit more background on the H1B is probably helpful. Typically speaking, an H1B is location specific and employer specific and job specific. It requires that the person be employed full time unless the petition is done as a part-time position. It requires certain salary conditions be met, so you can't just reduce the salary as you wish. So with COVID-19 coming and a lot of people not being able to work or having to work remotely, it created a lot of problems, and there has been some guidance on how to do that, as well as some workarounds. So if you're moving to a new job location in the same area of intended employment, and that is basically something within normal commuting distance, the government is not going to require the employers to file something called the LCA, that labor condition application that shows what the wages are. So if you're just moving someone to their home to work from home, then you would just have to, this is what is really the silly part, you have to post this labor condition application in the person's home. So I have to laugh. It may not be as funny as everybody else, but the labor condition application is filed with the Department of Labor to show that the wage is okay. But in order to prevent employers from falsifying that information, you have to post it at a couple of places at the work site where you would normally post notices to employees, such as your employment rights posters and so forth. So it really serves zero purpose whatsoever to post this in the employee's home, as the employee would have a copy of this document regardless. But they are actually requiring this. So it's probably most people who are working from home are already there. And so if you have it posted, the LCA, technically you need to do that as soon as possible so that it can be done. In kind of general considerations for reduction in force, whether it's a pay freeze, a reduction, or reduction in hours, there are a lot of issues that come up with H1Bs. As I mentioned, the labor condition application requires a certain pay and a certain number of hours, and so a pay freeze, an hour reduction, those sorts of things, or reduction of benefits, can be problematic. While they work for lots of other employees, instead of terminating the ones you're dealing with, you may have issues still with dealing with H1Bs. But in order to work through those, some of the options you can look at is like reducing overtime and that sort of thing. Discontinuing temporary or part-time employees, or terminating non-performing employees is kind of a first step to avoid having to deal with an H1B termination. But if you are going through a RIF, the first thing to do is you want to basically document the financial conditions necessitating the RIF. You want to identify the goals of the staff reduction. You want to consider, having a group of people oversee everything and creating a written plan, and determine if there's going to be some sort of severance or things like that, tax implications, and check with the local state laws. The risk can affect both non-immigrant and immigrant foreign workers. As I mentioned, employers' wage requirements, the reduction in wages, hours, or benefits can all be sort of problematic. In conjunction with that, there's something referred to as anti-benching that basically comes from the idea that stemmed out of the computer services industry, that you would only put you only pay workers when they were working on a contract, and when they weren't working on a contract, they would have been essentially be on the bench like a staffing company waiting to place someone, where you can't do that. So you wouldn't be able to take an H1B worker and just sort of bench them to deal with a RIF issue. You also have potential citizenship discrimination claims, national origin discrimination claims. You also have to make sure that any terminations of foreign workers is done in compliance with the regulations, and so forth. So getting a little bit more into the weeds of the H1B wage obligations is they are in effect during the entire approval period. So if I have an H1B approved for 3 years, which is the maximum an individual H1B can be approved, that is the period of my wage obligations. If the employee quits during that period, then that ends my wage obligations as a matter of law. However, it's still a good idea to go ahead and withdraw everything. If the company is the one making the termination, then it's even more important to ensure that everything is withdrawn with respect to the H1B, and the employer offers, and I accentuate the word offers, return transport to the individual. As a condition of the H1B, an employer has to agree to pay for return airfare for the employee if the employer terminates the H1B early. This does not include paying for moving furniture back or moving family members. It's just the airfare for the employee, and it has to be offered. It doesn't necessarily mean that it will be paid or that the employee will take it. The company just has to make it available in some form to the employee to choose or not to choose to take it, and document that. And another thing about the required wage is what the wage that has to be paid, and that is the higher of the actual wage or the prevailing wage. And this is where it gets a little bit confusing for some employers and people who are unfamiliar with the H-1B process, but it's never possible to pay an H-1B worker less than you pay a U.S. worker, because the government will issue what they consider a prevailing wage for the job and the location and the requirements, and the wage cannot be lower than that regardless. So that sets a floor for the wage. If the wage that you pay other workers is higher, then that raises the floor. So if the actual wage paid to other workers is higher than the prevailing wage, then you have to pay the foreign worker at least that actual wage. However, if the actual wage is lower than prevailing wage, it doesn't lower the wage requirement. The employer still has to pay the prevailing wage. So the required wage is always going to be at least as much as U.S. workers are paid, in some cases more. And so it is more expensive to employ an H-1B, contrary to a lot of beliefs that H-1Bs are cheap labor. And that wage has to be paid the entire time that the individual is employed under the H-1B or the H-1B is in effect. So as we explained earlier, there's the anti-benching. You can't place employees on involuntary leave without pay. So to distinguish, if my employee comes to me and asks, to take leave for some specific reason, maybe FMLA or something along those lines, that's perfectly fine. The employee can take that leave, and that relieves me of my obligations to pay the wage. But if I tell the employee you have to take 2 months leave, then that triggers the benching rule. Now, one of the things that came up quite a bit during the COVID-19 furloughs and so forth was employees effectively offering to take leave because they didn't want to lose their jobs or something like that. And that's very risky territory, because even though the employee is asking, it's effectively under duress, and it can be that the company is deemed to have forced the employee to take that leave rather than be terminated. So we don't recommend that. The employees can make claims for back pay and penalties. And there is a 1-year statute of limitations, but it's not told until the employer effects an actual bona fide termination. So if the person has 2 years left on their H-1B and you don't withdraw everything, then that effectively extends the statute of limitations by a couple of years. So furloughs, so mandatory furloughs, again, is to tie to that whole unpaid benching concept. If you have any unpaid involuntary leave while still present in the U.S., that's a violation of the benching laws. You're required to pay the required wages during an involuntary in-country furlough at any point. And again, back wages, civil penalties, and more. So there are some exceptions to this. So as I mentioned earlier, if the employee for unrelated reasons requests leave, that's going to be okay. There's conditions that render the worker unable to work, or there's just been a termination, then the duty to pay the foreign worker those wages no longer applies. There's also the idea of out-of-country furloughs. And so from a immigration and legal standpoint in the U.S., if a person is not in the U.S., that person is not covered by the immigration law. So if I am working under an H-1B and I decide to go home for a month, during that month, I am not required to be paid under the H-1B because I'm not physically in the U.S. And so a lot of people are taking the view that if you send someone out of the country, then you've effectively furloughed that individual without without violating the immigration laws. On the other hand, because you're forcing the employee to do that, you're at least violating the spirit of the anti-benching law. And so it's something that could be argued to effectively be a termination. You've told this person to go back to their home country, and so you may be liable if you haven't withdrawn the H1B or you didn't offer return airfare. So if the person is out of the country voluntarily for some reason, it's fine, but we don't recommend that employers send their employees out of the U.S. to avoid having to pay them. And again, just the voluntary leave issue. If it's truly voluntary, it's not a concern to not pay the individual the wage. There are other options for reducing a force that don't necessarily involve a furlough. You can have a reduction in work hours. It is permitted to do this, but there are risks such as back pay, civil monetary penalties, debarment from immigration petitions. You can have 5,000 fines for lowering hours and classifying people as full-time employees. And you may be debarred from all immigrant type petitions for 2 years if it's willful. So we have to be very careful in how we do that. And then there are basically just a few different ways that this can be done. If you're doing an across-the-board reduction in work hours, for H1B workers who will work less than 35 hours per week, you would need to obtain a new labor condition application and amend the H1B reflecting a range of hours. So you can reduce the hours below 35 if you amend the H1B, and that will ensure that you are in compliance with all the laws. The issue with this, of course, is that there are costs associated with filing and amending all of these H1Bs, and it may make more sense financially to keep the workers employed full-time versus pay the additional costs needed to be able to reduce their hours. As a result, however, you also have relations issues with your non-H1B workers, people who are have their hours reduced while the H1B workers do not. Obviously may have complaints with respect to that. So any kind of justifications for making these decisions has to be well documented to explain the action. You can also have across the board reduction in wages. So as we mentioned, you have the actual wage and the prevailing wage. If you cut the actual wage, but you still are above the prevailing wage, then arguably you can reduce the H1B workers' wages as well, because you're reducing the actual wage for that position. Obviously, it can't fall below state or federal minimum wage requirements or overtime requirements, but that's typically not going to come up in the H1B context. So there's kind of three schools of thought about whether or not this is okay. One is that it's permitted. One is that it's permitted if there's a range stated on the LCA. So as we mentioned, you can amend the LCA to put a range on there instead of full-time. Sometimes H1Bs start out this way, and they put a range. Well, sorry, when we play a range, we basically mean a range of salary, not a range of hours here. So if you have a range saying the position pays between, say, 50,000 and 70,000 is what we're talking about when we say a range in this context. And then the other school of thought is that it's never permitted. So looking at these under the different views, the permitted view is based on a purported statement from the DOL in 2002 that a wage could go down in an across-the-board reduction without amendment because the DOL understands fluctuations in salary. And then there's a 2003 discussion from INS Immigration Naturalization Service, which is now CIS, commenting they had discussed the matter with DOL, and then said it was okay as long as the employer otherwise complied with the LCA requirements. They didn't define what otherwise complying with the LCA requirements meant, so some question as to whether or not that provides any protection at all. The next view is the range view, and as I explained earlier, if you have, say the position pays 50 to 70,000, then the idea was brought that if you're not going to go below that range, then you are allowed to reduce the salary to the bottom of that range as long as everything can be documented. And this does address suits that have been brought that allege that a wage stated on an LCA is a contractual obligation. It's usually not successful, but it has been made. So it's viewed as the range view. A lot of people view the range idea as being the safest way to do it. But there's an argument to be made that it shouldn't be done at all from a risk prevention issue. And there actually is an administrative review board case from 2005 from a company called QuickCat that held that the LCA rules only permit an increase, never a decrease. So they interpreted the idea of wage fluctuations to go up, not go down. The case did not specifically consider LCA wage or business purpose in decreasing the wages. It simply found that the decrease was not okay, and the employer was found liable for back wages and willful violation after having applied a 15% across the board reduction. So we're talking about the same type of scenario that we would have in a salary reduction under the whole furlough situation. And the court did not address whether or not a range on the LCA would have prevented this. So this case, in my opinion, completely contradicts the idea that it's always okay to reduce wages as long as you do not go below the required wage. It doesn't necessarily rebut the wage range option. So some people may still want to consider that, but this case does show that there is a high level of risk with reducing the wages at all in an H1B situation without amending it. As a result, I recommend that at first you at least look at the prevailing wage to see if the wage has been raised, because sometimes you may find that the prevailing wage has actually gone up, and if you redo the LCA, you're going to end up having to pay more money than you do now. If you're okay with the prevailing wage, then file a new LCA and amend the H1B petition. Of course, as I mentioned earlier, you want to determine if the cost of refiling and amending is actually going to, cut into any anticipated savings such that it doesn't become useful. But I think that this is a much better option versus taking the risk of the back wages and penalties that have been assessed in cases like QuickCat. So across the board reduction in benefits is a little bit easier to deal with, maybe not as effective in terms of saving costs, but you can do it. If you implement across the board benefits, that's going to be okay. If you choose not to extend the benefits to all newly hired workers, including foreign workers, that's one way to do it. And you can also allow H1B workers to voluntarily opt out of benefits. So as long as the offer and waiver are clearly documented. Again, you don't want to force them to opt out of it, but if they want to voluntarily opt out of it, that's a possibility. Of course, if you have a collective bargaining agreement or other employment contracts, those may cause issues with that strategy as well. Another option, at least in the H1B context, is to delay the worker's start date. And so there are situations where you can, if you have a person who hasn't entered the U.S. yet, or has not activated the H1B, or simply has not started working, there may be options for delaying it. And there is no grace period for delaying salary, though. So once the person makes themselves available, you have to start paying that wage. And if you have a situation where the person is switching from F1 to H1B, you'd have to pay that wage on the effective date of that transition. But it is possible in certain situations to delay that start date and avoid having to get the individual paid. Of course, you could also withdraw an H1B before you start someone altogether, and that eliminates the H1B obligations as far as the return home and so forth. So before I move into a slightly different topic, I did want to go back and just address a few questions. There was a question regarding I-9 verifications in the remote worker context, and whether or not we recommend or provide this service. We do not have any vendors we specifically recommend for this. And while we can do it as our firm on a case-by-case basis, we don't provide it specifically as a service. To kind of explain that concept, if anyone's not familiar with it, when I do an I-9 completion, I have to view the I-9 documents physically present with the person presenting those documents. And so when you deal with remote hires, it creates problems. And there are companies out there that will provide services like this. If you Google remote I-9, you may find some. Depending on how often you encounter this problem, there are other ways to deal with it. In some states, you can use a notary. Some states have prohibited notaries from touching immigration documents, but the notary in that case is not acting as a notary; they're acting as an agent, as a company, to complete the I-9 on behalf of the company. And literally anyone you trust to complete the I-9 for you can be your agent for that purpose. So if you can identify anyone in a given location that can complete the I-9 for you, you're allowed to use that person as your agent. Of course, you are responsible for errors that agent may make, but that is an option in most cases. Right now, because of the COVID-19 situation, when a workforce is completely remote, CIS is allowing flexibility in that requirement. So there's no requirement for in-person right now, but there would be once we have a normal return to work. If you have anybody if you don't have a completely remote workforce, then you're not eligible for that. However, if there's a specific COVID-19 related issue, such as the person who's supposed to do it or the employee cannot be present because of a COVID-19 restriction, they will consider that and likely, waive any kind of penalty associated with that specific individual. But again, we don't recommend any specific service for this. Another question that came up is due to the closing of a lot of the CIS offices, a lot of appointments were rescheduled or canceled for everything from interviews to biometrics. And the question is what is the timing frame for those dates? We don't have good information on that. We have seen biometrics start to be scheduled again, interviews start to be scheduled again, but any given office has its own backlog, and knowing how long it would take a given office to get people back in line is unpredictable. But we are seeing interviews and biometrics being rescheduled. At the same time, there are expected to be several thousand CIS officers furloughed at some point. It was supposed to have happened by August. It's been delayed. We don't know how that furlough is going to impact their workloads. and that may ultimately cause additional delays in these being rescheduled. But what we can say at this point is that they are starting to reschedule those appointments and interviews now. So it could be relatively soon for that to be available. Next, I'm going to go ahead and move into discrimination concerns related to RIF and so forth. And so when you have a discrimination claim associated with a RIF, it's usually an accusation that the company is targeting a protected class for reduction in force. Protected classes are U.S. citizens, U.S. nationals, lawful permanent residents, refugees, and asylees. And so if you were to say terminate all lawful permanent residents, which I've never actually seen happen anywhere, but let's say you did that, that would be a violation of the law because you are choosing a protected class of individuals to terminate. Immigrant workers, non-immigrant workers, people on H's, L's, and so forth are not a protected class for that particular claim. However, they may be based on national origin or nationality. So if you have a workforce of H1B holders who happen to all be a particular nationality, or you only terminate H1B workers of a particular nationality, they could come back and say that it was based on their nationality and not based on some other factors. So it's important to ensure that you document the reasoning behind those decisions. Favoring H-1B workers over a protected class of workers is a violation of Title VII and other employment statutes regarding citizenship and national origin discrimination. This gets a little bit sticky. Obviously, if you hire H-1B workers over U.S. citizens because you just prefer H-1B workers, that can be problematic. So again, the reasoning behind hiring H-1B workers instead of a U.S. citizen has to be well documented. There's a case called Santiglia v. Sun Microsystem where they actually found that there was no discriminatory contact despite the fact that U.S. citizens were laid off while 4 foreign workers in the same division retained their jobs. So the reduction in force plan was applied systematically and deliberately. They were based on individual assessment of each case, including business requirements. So, for example, this is where the H-1B may be more difficult to amend, reduce, or so forth. And so you're going to furlough the U.S. worker instead. This is the type of thing you would have to document as a business requirement, and as well as the individual's performance and those sorts of things to make that determination. In this case, it was also the same manager who had laid off the individuals who had hired them. So it's covered by something called the same master rule, which suggests that the person isn't discriminating by terminating someone or furloughing someone if that's the same person who hired them to begin with. So kind of going in the opposite direction, it is perfectly permissible to simply terminate all H-1B employees and be done with it. As I mentioned, they're not a protected class, so they're not going to be able to make a claim under that. Of course, as we also mentioned, if they're all the same nationality, that can potentially be a national origin claim. So there has to be an explanation and documentation as to the basis for making that decision, so you're not potentially liable for a national origin claim. And the counter arguments you would make for that are basically cost of the H-1B, lack of flexibility, filing fees, all those sorts of things. If you look at what the entire point of this presentation about the difficulty of dealing with H-1Bs during furloughs and stuff like that, those are your arguments for why there are legitimate non-discriminatory reasons for eliminating all H-1Bs. So again, you just want to make sure you're documenting those. When you do terminate an H1B, as I mentioned, to effect the termination, you have to withdraw everything, which means withdrawing the LCA from the Department of Labor, withdrawing the actual H1B itself from CIS, and you must offer return airfare, as I mentioned earlier. The worker does have a 60-day grace period subject to the prior expiration of the H1B. So if the individual has more than 60 days left on their H1B, they would have the full 60-day grace period. If they had less than 60 days left on their H1B, then they would have that amount of the grace period. And that's relatively new. There used to be no grace period at all. So once you terminated someone, they were immediately out of status, which led to all kinds of negotiations about leave and severance and those sort of things that we shouldn't have to worry about as much anymore. As I mentioned with the return airfare, there's no specific format. The government takes the position that it's a contractual arrangement between the H-1B employee and the employer. Whether your company purchases a ticket or provides funds or has a booking service or a voucher, doesn't matter. Just have a uniform policy and adhere to it. And if you do pay funds out to the individual for the airfare, you need to clearly note that the payment is for the return airfare, not for wages earned, not a severance payment. It has to be clearly documented that the wage is specific, or the amount is specifically for the airfare, not wages or anything else. If you give severance payments, you should pay those in lump sums. The workers often ask for them to be paid over a period of time to keep up the appearance of continued employment. I mentioned with a 60-day grace period, it is less of an issue now. We don't see it as often. But the Department of Labor basically interprets that if you're continuing to pay the individual over a period of time, the individual is still employed because all of the requirements have not been met. And so a lump sum and concluding the employment and the relationship immediately is the best way to go. Lastly, just to kind of summarize, any reduction in force should include careful documentation, business decisions, the selection criteria. The criteria should be applied uniformly. You should have comprehensive training guidelines, et cetera, for the personnel involved. You need to have ongoing communications between Human Resources departments and Immigration Council and Employment Council as well, for that matter. And there should be a kind of an assessment whether or not the overall RIF would have some sort of adverse impact on a protected class of employees, and take that into consideration as you move forward. And with that, concludes the presentation for today. We give an opportunity for any additional questions before we part. If anyone wants to take a few minutes and send a question over now, I'll be available to answer that. So we got another question about some ways that an I-9 form can be completed when hiring an out-of-state employee. That is going to depend on the situation. But again, as I mentioned earlier, you have the option of literally using anyone you want as an agent. So if you have a business partner or vendor you work with in that location, you can use that. You can have the employee come in for orientation and use that option. It's important to remember that the page 1 of the I-9 has to be completed on the day the employee starts work, and then you have 3 additional days to complete section 2. You can delay the employee start date. You can arrange if the employee comes in, does the I-9, and then starts at a later time. You can use a service, as was mentioned earlier. There are services available out there. A lot of notaries, depending on the state, will do this for you. California is one of the states where it's not possible because of their really strict rules on notaries, but in most states it's possible. Again, you just want to make sure that you're conveying the instructions to the notary that you're not asking the individual to be a notary, you're asking them to be your agent. So they're not notarizing the documents, but rather verifying everything and completing the I-9. One thing I don't recommend, but which is possible, some people even have a family member of the employee complete the I-9. It's legal, but I have the one time I've seen that done, the individual was not in fact authorized to be employed. So, you can't trust necessarily the family members to provide you good information. If you work with, like I said, a vendor, go to a law firm, as I mentioned, in certain situations, we can, on a case-by-case basis, help with that. And I'm sure there's a lot of other companies that take that view as well. The rules have just not caught up to the reality yet of remote employees. With E-Verify being out there and potentially the move to a mandatory national E-Verify at some time in the future, we're hopeful that there will be an online way to do this. But at present, it's a very integrated system, and there's just not a good way to do it. So a question about switching from F1 to a work visa. Any individual who is in the U.S. In valid status can apply for a change of status to a work visa. The question is just a simple matter of what that work visa would be and whether or not it's available and the individual would qualify. If you can apply for a change of status, you do not have to get a physical visa in your passport, and therefore the proclamation related to not issuing H1B visas and so forth would not apply. So as long as there is a visa that an individual is qualified for, it's possible to do a change of status in the U.S. and still be able to get it.
All right. I think that's all the questions we have for now. If anybody has any additional questions for David, please feel free to email him. Email's on the bottom of the screen, and I'd also be happy to forward any questions that anyone has.
Right. And I would just like to thank everyone for participating today, and I hope you found it useful.
Thank you so much, David. We got some great information today, and we really appreciate you presenting for us. So once again, if you do have any additional questions for David or about the presentation in general, please feel free to email me. My email should be up on the screen. It's anna@hrsimple.com, and I can answer any questions or just pass them along to David if necessary. Also, just wanted to remind everyone that we are extending the 30% discount off all HR Simple products with the code up on the screen, COVID Webinar 30. And I will be sending out the recording and slides within 24 hours. You should get them today by end of business, though. Thanks for tuning in, everyone. And once again, thank you, David. This was a great presentation, and have a great day.
Thank you.
Thanks.